Good morning, Word Fam. How's it going? Happy to see all your smiling faces, or at least I hope they're smiling. Man, a lot of people must be on the StreamYards today. Their bandwidth ain't good. So let me say good morning to everybody. Good morning, Sugar Beet. Good morning, Yvonne. Good morning, Nacho Mama. Good morning, Rachel. Good morning, Queen of O'Hara. Good morning, Amelia Sparkles. Good morning, Chick Tracy. Hi. All right. So, are we ready for another exciting day of who's going to testify as a rebuttal witness today for Team Johnny Depp? And how will Team Amber Heard make the most use out of their 1 hour, 16 minutes rebuttal time? I'm very curious. I don't have a very good feeling about it. I'm not even going to lie. I really don't. I mean, because I know that Johnny Depp has at least one witness today. So I would think, depending on who it is, obviously, because I can't know all the things, but depending on who it is, I would think that Team Amber would want to cross-examine. And cross-examination it counts against your time left, right? Now, the judge has said that if the time is up for either side, the time is up. She didn't say this is not a direct quote, all right? But basically, she doesn't give a rat's fat kneecap if they're mid questioning. She will stop the clock and that will be that. The end, period. So she's not playing around. Okay. So I have no idea how this is all going to play out, but I'm sure glad you guys are here with me to watch. Hey, Cement Shoes. Hey, Nui and Honey. Good morning, good morning, good morning. It's good to see you guys. Hey, Ali79. Hi, Yashmita. So, as far as Amber Heard taking the stand, here's the thing about Amber Heard taking the stand, okay? At this point, after the metadata witness I don't I I don't see how she couldn't take the stand. I mean, obviously, they're not going to put her on the stand to rebut Dr. Curry. That would be ridiculous. She's not qualified to rebut her. But she now, I don't think that they would have her rebut Johnny Depp's testimony about the rumor, because that would be ridiculous. But here's the thing. If she, so, depending on what they ask her on her direct rebuttal, right? That is how the cross-examination questions are determined. It's a little bit different on rebuttal. Hey, Welsh Pam, good to see you. So, bruh, I don't even know. Because if they were to ask Amber Heard, did you ever ask Johnny Depp, or wait, what would be a better example? If they were to ask Amber Heard, where did you hear the rumor? About Kate Moss. Now, she can say where she heard the rumor. What she cannot do is say what the rumor was. She cannot say what the person or whatever, if it was a news article, whatever it was, however it was the rumor came into her brain, right? She cannot say what she was told, right? But she can say where she heard the rumor. All right. So if they do that, which would be ridiculous, this would be stupid for them to do, because then on cross-examination, the Johnny's team could very simply ask her, and this would be a very logical question: why didn't you ever ask Johnny Depp? I mean, for Pete's sake, you were married to him. Before you were married to him, you were dating him. Why didn't you ever ask? So and again, I go back to the time limit. I think she's going to be on the stand. I do. But I just can't figure out, because they never do things the way that I think they should do them, because they don't call me and ask me, right? And they clearly don't watch the show, because if they watched the show or the stream, they would find tons of useful tips and tricks, right? But they don't. So I have no idea how they're going to. I just have no idea. I really don't. I would imagine that they're going to use the bulk of their time. It has to be. It would have to be on Amber Heard. If they're going to call her, which that's the rumor that they're going to call her, they would have to use a lot of their time on her. Otherwise, what would be the point? You know what I mean? So, this is going to be a mess, y'all. I have no idea. We're all going to be surprised. Just waiting for the channel I like. But if I'll just do like we did. Oops. Let's do it from where I did yesterday. Tired of waiting. I get annoyed. I'm not a good waiter. Not good at waiting at all. All right. So they're showing the entrances. So let's be sure we want to watch that. Come on, Jen. All right, here we go.
Good morning. How are you?
2 more days. Do we have any preliminary matters at this time? Okay, sure. You wanna come forward?
Thank you, Cement Shoes. So, Nui and Honey, I think we would, I think we will get a warning and then a stream because that's once the case goes to the jury, right? Every media outlet that is streaming this trial is going to be waiting on pins and needles. Friday, Nacho Mama will be waiting on pins and needles for word that the jury has come back. And so keep your notifications on, make sure that they're set to all. And I will go live with the verdict. Of course, we have to see this through. We watch this as a family. We're going to find out how this ends as a family. Period. Also, I would just like to, I've seen, and hi, AJ, good to see you, babe. Let me just say this because I'm annoyed already. Dear Amber Heard, the loose hair on one side of your face is not a good look. First and foremost, you fidget entirely too much, okay? It works well in photos, right? It is not an everyday do. Okay? Stop doing that. Tell your hairdresser, hi, Callie. Tell your hairdresser that Jen Liu from the ward has told you not to do that anymore. It's not a good look. And I don't think that Jen Liu stands alone in this. I feel that there are plenty of other people on other channels all around the YouTubes, all on the Instagrams, all on the TikToks, all on the Twitters who would say the exact same thing. There's probably tens of people who think that that's a good look. All right. But the rest of the internet's doesn't like it. Okay. Hey, Savannah. We're done with that do. Just stop, ma'am. We're over it. You're going to get a 1-star Google review because Google won't let you put 0 stars. So you get 1 by default. And that's it. Lady. I really cannot handle that hairdo, you guys. I don't know what's wrong, why I feel so personally attacked by that hairdo, but I do. I really do.
All right. Good morning, ladies and gentlemen.
Good morning, Your Honor.
All right, your next witness,
We call Dr. Richard Gilbert, Your Honor.
Dr. Gilbert. No.
Do you solemnly swear or affirm to testify truthfully in this case for penalty of law?
Sure, why not? I love to try new things. Let me try telling the truth.
Good morning.
That should be fun.
Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I trained in orthopedic surgery and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years?
Okay.
Ooh, Johnny
What
looks
percentage
very
of
dapper
your
and taupe.
practice over the past 22 years has
Hello.
involved surgery?
Approximately 1/3 of my practice.
And other than that 1/3 that involves surgery,
Yes, I
what does the
did.
rest of your practice
She
entail?
kills me. I love her.
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively. A large portion of hand surgeons treat patients non-operatively.
In terms of the surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to tendinitis to injuries such as amputations, fractures, sharp lacerations, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994, so that would be 28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Have you testified as an expert before?
Hey, Max
Yes, I have.
2002.
Can
Thanks
you
for being
ballpark
here.
for us how many times?
Certainly less than 10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specializing in the hand.
All right, any objection?
No objection, Your Honor.
So moved.
So, Dr. Gilbert, what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs, pictures, as well as testimonies and depositions related to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Yep, that's what he
Are you
said.
aware of other explanations for that injury?
Hey,
There have been
Shalima,
multiple
good morning.
other explanations, but I think the one that was brought out was by Ms. Hurd, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Based on your
Okay,
review
that's
of
a good
the
question,
medical records,
Allie.
and and other documents in connection with Mr. Depp's
I'm
finger.
in my first
How would you
inclination
describe
is to say
the
no.
nature of the injury
I
to
feel
Mr.
like
Depp's
they
finger?
can award damages, but I don't know
Well, the
that they
nature of the
have the
injury
power
was,
to say how the
we had
damages
what we
must be,
described
but
as a
I don't know
comminuted
for
fracture
sure.
of the distal
But I don't
phalanx,
think I've ever
meaning
heard of
a
that
fracture
happening.
of
You
the
know?
tip of the finger, and comminuted
Yes,
meaning
Sarah,
the
this
local
is Johnny
features.
Depp's witness,
So this
babe.
is some type of blunt force
And if I haven't
with a
said
high
good morning
mechanism
to
of
you,
injury.
good
He also
morning.
sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
Can you take a look at Plaintiff's Exhibit 60? And pull up to go to page 3. And Dr. Gilbert, are you familiar with this document?
Yes.
And what is it?
So these are two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection? All right, we'll identify it as 60, page 3, and publish to the jury.
And Dr. Gilbert, sorry to cut you off
that's
there. Can you just tell the jury what we're looking at here in this
we're looking
X-ray?
at two x-rays of Mr. Depp's right middle finger after the injury, and towards the tip of the finger.
First
there's a
of all,
fracture.
Sarah, how
Again, what I
dare
described as
they?
a comminuted fracture, meaning
Don't
there are
they
multiple
know?
pieces at the tip. There's also a transverse component to the fracture closer to the joint.
See, I think the term thrown
In
is
your view, what types of mechanisms
probably
cause
not
the
completely
surgery?
accurate.
So this is a mechanism of
I
injury
think
that
she
has
hit it and
high
let go.
velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as is seen in these x-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Hurd?
I think that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Hurd described?
So if that were the cause of the injury, you would certainly, that would be a dorsally directed. So this is a dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed. And those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again, I said is rare. So you would see either loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any sign of anything like that?
None whatsoever.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded. So it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along the ulnar aspect of his finger.
Now, did you observe? the
Okay, Chick
testimony
Tracy,
of
I'm just glad you're
Dr.
here. Get some
Mr.
rest,
Moore?
babe.
Yes, I did.
And he testified about Mr. Depp's finger injury as well.
Correct.
Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes, but not all of it.
Focusing on the parts that you, well, first of all, why don't you tell us what you agree on?
Yes,
Well,
tell
I
us
agree
there.
in terms of his interpretation of the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
What did you disagree with?
Well, I disagreed with several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
Anything else come to mind that you disagreed with?
Well, he also described that this was definite. Well, he thought that this was a pinching, or what he described as an avulsion type injury. And
Hey,
that's
Tony.
referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges. It was not jagged. And generally, when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss, and just to make sure we're on the same page.
You know what I want them to ask?
You're referring to there.
Right. So
Hold on, I'm going to
there
pause
were
this real
two-
quick.
Two components to this injury. One, the fracture.
Okay, so you know what I want them to ask? I want them to ask if the injury, the cutting injury, the cut, if it appears as if the same amount of pressure was applied to the edges of the cut evenly. Because remember when we were watching, and there's been a ton of trials, but this one was just a recent one, the Ezra McCandless trial, and the emergency room doctor, the physician who was the first one to observe her injuries, said that there were hesitation, and that and then obviously the direction was made it appear to be self-inflicted. And so what I want to say, I want to ask that because it's very difficult to harm yourself. Like it's against your fundamental will to survive. So when, even if you're like blitzed out of your mind, I mean, certainly that would make it easier somewhat. It would make it easier for you to have the nerve to do it, but at the end of the day, the pain is going to be what causes you to stop. So I'm curious about that. That's all I wanted to say. Okay, let's get back to what he's saying.
Fracture of the bone, and two, he had loss of the soft tissues, so that the bone was exposed. So that amputated part that was found at the bar.
Now, you were saying that Dr. Moore testified that this was an avulsion, and meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Well, again, in general, a pinch type injury results in one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged, and that's not what was depicted in the pictures.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
Correct.
What's your response to that?
I certainly believe that a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient force to result in this fracture and soft tissue loss.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all? The fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Good morning, mi amor, Michelle.
Do you have
Whoa.
any opinion regarding the direction of the injury?
Ooh.
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence
Where was
of
Miss Heard in her handy dandy
broken glass
recording?
Mr. Depp's injury. Do you remember
She's
that?
always recording
Yes, I do.
things.
And how does the absence of glass fragments factor into your analysis?
It really doesn't.
One we don't care
I've
for.
seen hundreds, if not, probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if just say a wine glass would explode or something of that nature, where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
I have no further questions, Your Honor.
All right, cross-examination.
No, she didn't. Sugar beet. She sure did not.
Thank you, Your Honor. Good morning, Dr. Gilbert.
Good morning.
Hello, Mr. Rottenborn.
Now, you're being paid $1,000.
Here we go.
In this case, correct?
Correct.
And you agree, just to sum up how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
Correct.
And you're aware, you said a few times Ms. Heard's account or Ms. Heard's explanation, right? You remember saying that?
Yes.
you're actually aware that Amber has said she doesn't know how he lost his finger. You're aware of that, right?
Yes,
So when you were just talking about Miss Heard's account or Miss Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger, correct?
no,
You're aware that Miss Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
no, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that, that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agree. Miss Heard's testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger.
But she
with
testified
that,
in a
correct?
deposition, and so
I
what he's saying is
Agree, I cannot
that
speak for
didn't
her.
happen. It didn't happen that way. It didn't happen by punching something. Calm down,
Right, Coach Ryan.
Rottenborn.
Yes, sir.
You gonna ask about his 15 minutes of fame next, or is that just Elaine's job? Okay, sorry, that was inappropriate.
Dr. Gilbert,
Let me calm
you gave a
down.
deposition in this case
I'm
on March 17th.
Too hype.
Correct,
You were under oath in that deposition. You swore to tell the
Correct.
truth, correct?
correct.
Okay, if you could turn to page 61, please. You see there are four pages per page of paper.
Amber, what are you writing out? A
16
grocery
document.
list? What could you possibly have to write?
Okay, in line 9, you're asked a question, and then Amber's response to that question, that's the line 9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I'm aware from reading, I am from reading this. I'm aware of the mechanism.
I think
that
Savannah,
would
because there was
cause the finger
conflicting
injury.
stories from
Question,
Johnny
but
Depp,
have
who
you
would have
read
been the
anything
victim,
so far
and it would have been
that indicates
difficult
she
to
doesn't know
prosecute.
how the finger injury happened? Answer, so far from what I'm reading here, yes. Did I read that right?
Yes,
And you've heard no testimony in this trial from Ms. Heard that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
correct,
And you'd agree that the fingernail was uninjured, you said that, right?
correct,
And the nail bed was uninjured,
correct.
correct? But the area under the fingernail, the pulp of the finger, that's where the injury took place, right?
It was not isolated to the pulp, no.
But it didn't injure the fingernail, that's my question.
Correct, yes.
And under Mr. Depp's
I mean,
alleged theory,
what could she
Amber
possibly
threw a vodka
contribute to
bottle
this
at him from 10
testimony?
feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from.
Also, why is she
Correct.
wearing
But
taupe?
she threw it on a downward trajectory, correct?
Why is she trying to
There's
match
no
Shawnee?
allegation you've never read anything that
Again,
somehow
who gave her the heads
underhanded
up?
it so it came up to his finger, right?
Correct,
And there's no way to tell, as you testified, what exact direction it came from, right?
correct,
And the glass exploded, but you've already testified there was no glass in the wound, right?
correct,
You haven't read any record of that. In
The
any
wound
medical
was
records,
cleaned.
Correct?
correct,
You also haven't read anything about there being cuts on the rest of his hand, right?
correct,
And there was no glass found anywhere on the rest of his hand, correct?
correct,
No bruising or injury on any other part of his hand other than the tip of his middle finger.
correct,
And somehow, under Mr. Depp's theory, that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail. Correct?
correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there, and I don't have videotape of the injury, so I can't determine that definitively.
Okay. Well, let's turn to page 25 of your deposition, please, on page 7.
Savannah, I don't know how she would have gotten him with the cigar cutter, babe, because the way that a cigar cutter
So
works, you stick the
25 and
cigar
26,
through the
so it's
hole, it's
page 7
circle,
of the
right?
doc.
Okay.
So
Sorry if I
how
wasn't
would she
clear.
be able to
Well-
only get one side of his finger with a cigar cutter? I mean, if we're talking about cutting, I could see some
Okay.
tin snips maybe.
Line 18, question, and to be clear.
But in order
by,
for them
quote,
to,
sitting
in
that
order
position, you
for,
mean hand down,
hold on a
palmer
second.
side down.
Let me pause this.
Answer, that's what he claimed. I mean,
This is the problem with with a cigar cutter or even tin snips. So if somebody were going to use tin snips on somebody else, it's to actually cut the finger off, right? Either at the first knuckle or the middle knuckle or the entire finger, right? So, yeah, but hold on. Wait, just give me a second. Okay, so the thing is that if it were just the cut, that would be one thing, but the bone is crushed. So that means force and pressure. It's, I mean, I don't know what Johnny Depp's bone density is, but even if he were asleep, you a cigar cutter it's a hole. You stick the cigar, which is the same shape as a finger, through the hole. Okay? So it would not cut just one side of the finger. It would, you know what I'm saying? Because it's intended to cut off the tip of a cigar. This whole circumference. So I just don't, I mean, maybe, but I just don't, I'm having a very hard time trying to figure that out. And I will say this, I've been thinking about this bottle story. Okay. And the truth of the matter is people make lucky shots every single day. And there are random accidents that happen every single day. And by accident, I mean, obviously Amber intended to chunk that bottle, okay? But she probably didn't intend to do the level of damage that was done, right? If that's what happened. To me, what it seems like is I have a very hard time believing that she threw it from a distance. I think what she more than likely did is she raised the bottle up and went to smash his hand with it, and he moved his hand and she let go of the bottle, which is what caused the cut, the crush, and the shattering of the bottle. The bottle had to have hit something hard because the bottom of a vodka bottle is thick. I mean, vodka bottles, liquor bottles are thicker than other types of bottles, generally speaking. Even a beer bottle is relatively thick, right? But it's to prevent exactly from what happened. You know what I'm saying? Like they're intended for it to make it be a little more difficult for them to be broken. So, yeah. So at the end of the day, that's really what I think happened. And I think is that for both of their parts, to be fair, the situation was highly volatile and there was a ton of emotion from both of them at the same time for different reasons, but the emotions were high. And sometimes when a lot of times when those types of events occur, there are pieces out of your memory that are missing because it's just everything happened so fast and there's a ton of adrenaline and a ton of emotion and all that. So anyway, that's just my theory. Okay, so let me push play so we can hear the expert witness say what he thinks.
according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmer side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred. And as well, you can't determine if his hand had moved at some point during the force of the injury, which I believe it probably did, which I didn't get into in my note here. But Question, and why do you believe that?
Let me
Have you
look for
read
them,
anything
Savannah,
in
for
any
you.
of the materials
I don't know if they're
that
going to
suggest
display
that?
them to the jury or
Answer,
not, so I'll look them up.
No, just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's incorrect.
Okay, that's what you testify to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
That is incorrect. That's not what I testified.
In
That's not
fact,
what,
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation is that it didn't happen how Mr. Depp says it did, correct?
I cannot make that assumption, nor can you.
No further questions. Thank
All
you.
right, redirect.
Dr. Gilbert, just very briefly.
It's
Yeah,
really
this is
difficult to
literally
find a
practice
photograph
on
of that
Depp's hand.
injury that
How do you
isn't
factor that
blurred.
into your analysis?
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanisms of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example. If you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury impacted the hand at that point in time.
Ms. Hurd's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Okay, thank you, Savannah.
And how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
And your discussion of Ms. Hurd's explanation of the alternative cause of the injury, was that based on anything other than Ms. Hurd's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you. You can just leave it there. That's fine. Thank you, sir. All right. Your next witness.
All right, give me just a
Plaintiff
second and I'll
Russell.
upload it for you
Plaintiff
guys.
rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure.
All right. All right, hang on just a second and I'll put it up. All right. Let me put it up. This is your trigger warning, but you guys want to see it, so here it is. on, pewter. Why be so slow? My computer's like, girl, I'm trying to do 11 billion things. Slow down. You got me downloading, uploading, streaming, sharing screen. All right. I don't need to have that open. That will help. All right, y'all ready? Here it is. This is your trigger warning. 5, 4, 3, 2, 1. There you go. What do we think? I just, I don't know. You know what? Now that I'm looking at this, okay, but let me ask you guys this. All right. This is where this is where the struggle for me is coming. If that's what happened, if Amber Heard put his finger in a cigar cutter, why wouldn't Johnny Depp just say so?
All right, rebuttal evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Acker.
All right.
So what do you think? Not your mama. I mean, a cigar cutter is a knife, right? Hello, right? Am I right? I feel like I'm right.
Do you solemnly swear or affirm to testify truthfully?
I don't understand why he would not just say that's what it was. They were not in the United States. I don't know what the laws are in Australia. Whoops, wrong thing. In Australia about
Can you please state your name? Julian Ackert. And can you please
cigars.
describe your educational background following high school?
Cripes, I pushed the
I
wrong
have
thing.
a
Almost
bachelor's
clicked
of
end
science
broadcast.
in
We're
computer
almost done,
science
y'all.
from the University of Virginia. What is your profession?
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data review and production services, all to the business and legal community.
What, if any, of those services performed by IDS have you performed?
I perform all of those services.
How many years of experience do you have in computer forensics investigation?
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have
Hold on, I have a
experience,
question.
creating and implementing.
Before we get into this gentleman here. Okay. So yes, obviously if the Australian police knew that she did that, then she would be facing charges. However, how successful would they have been at prosecuting her, given the fact that we're not even in a criminal trial here? We're in a civil suit. And they've brought up repeatedly the fact that Johnny Depp has told two versions of the story. The first version is that he pinched it in a accordion door, right? And then the second version is that she hit him with the she hit him with the vodka bottle. Okay, so I don't know. I'm not being a smartass. I'm actually truly genuinely asking about this. How does that work in a place like Australia? See, when we in America, when there's two conflicting stories, this is why the expert witnesses get brought in, and then ultimately it leads to a jury. But I feel yes, but but the thing is that how does that play over there? See, it over here, it unless there were witnesses that were willing to testify that they saw her throw that bottle at Johnny Depp's hand in the United States, this and I, not even Johnny Depp, just two people, okay? If there were no it would be very it would the DA here in the United States would be extremely hesitant to prosecute this type of a case where there were no witnesses and the victim themselves gave conflicting accounts. They would be hesitant. I'm not saying they wouldn't. I'm just saying they would be hesitant. That's all. That's what I'm trying to say. I agree that that's what he did. I'm just curious about how I don't know. I'm just curious how that works over there cuz it's difficult over here to get stuff like that prosecuted. Okay, here we go. I'm pressing play and we're going to listen to this gentleman.
Implementing data preservation and collection strategies, doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata.
Hey, Charlie.
Extract.
You mentioned collecting data from forensic collections. What material are you forensically imaging?
This would be any type.
Shmita and Nacho Mama are in charge.
An iPhone,
Behave.
an iPad, a tablet, laptop, a cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GIAC GCFE, that's the GIAC Certified Forensic Examiner certification.
And what were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Do you belong to any professional organizations?
I do. I'm a member of a conference called the Sedona Conference. It's a conference that is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
And has a court ever declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Acker as an expert in the field of computer forensics.
No objection, Your
All
Honor.
right, so moved. Could you just spell your last name for me, Mr. Acker?
Ackert, A-C-K-E-R-T.
Thank you so much, sir.
Mr. Acker, what is forensic imaging?
Forensic imaging is the process of capturing the data on a digital device in a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets, PDF files, any applications that you ran, the history of what you've opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to do that?
Log files list information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
what is the purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the data from the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracting photographs or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
I do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's an evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to use a small, medium, or large, or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding Photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's 2 types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And Mr. Neumeister was concerned with embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh operating system for laptops. This is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document, it could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version on those photos.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account, or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So the photo that was originally taken traverses or gets synchronized to other devices by design of Apple. And that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software exif metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up Defendant's Exhibit 1671? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying what the contents, just generally, what is it?
This is a chart I created as part of my report.
Your Honor, permission to publish Defendant 671 is a demonstrative.
Any objection?
No objection, Your Honor.
All right. It'll be published as a demonstrative.
Mr. Acker, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second. A little further up. Great.
Thank you. This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Heard's devices that did not indicate the software metadata field showing photos. Rather, they indicated that they were the original software metadata field of iOS.
And do you
Oh my God, I've been talking this whole time and I've been muted. Okay. So what I wanted to say, I wanted to address Sugar Beet's question, and I just wanted to pause the video because I don't want to talk over his testimony. Okay. So according to testimony given by Josh Drew and Raquel Rocky Pennington, they are the people who took the pictures of Amber Heard's injuries, different injuries at different times. Okay. But that's not really the question. It doesn't really matter who took the pictures. It matters which device the pictures were taken on. And both Rocky and Josh testified that they took the pictures using Amber Heard's phone. So what this expert witness is testifying to is the only thing that he can testify to. Were the photos altered? Because even if it were a criminal case, okay, with the same data, right, the same extraction, all the things, anybody who had access to any of Amber Heard's devices, her phone, her MacBook if she has one, or her iPad, which we do know she has for sure, would have been able to alter the picture. So they're never going to be able to prove who altered the pictures, only whether or not the pictures were altered. And that is what they're after as far as this goes, because that's all they could ever prove, whether it was a civil or a criminal trial. Nobody can prove who did what to a phone unless there were some sort of because Apple does have this. So does so does Android. Face recognition, which would be how you unlock your phone, or they do offer. Android offers fingerprint, and so does Apple. So that would narrow it down more. But still, if the phone were unlocked and somebody picked up the phone, they could, in theory, alter anything. So that's what they're after here, whether or not the photos were, oh, sorry, Corey, I'm so sorry. Whether or not the photos were altered or not, they can't prove who did it. And that's what he's testifying to. So that was a long way for me to explain it, but there we are. Okay, here we go. I'm going to speed him up a little so that we can be caught up. Just a scotch, just a 1.25. It doesn't really change things. Okay, here we go.
You see the second column titled Neumeister Report Date Captured.
Yes, I do.
What does the information in that column mean?
This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured, or the date captured is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
You're welcome, Sugar Beet.
Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry, the right-hand column of this chart,
Yes, I do.
and where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for each of the items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect, for example, a phone or a laptop, and the matching file name found on that evidence ID that indicated the original version of the same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up? What does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and follows by another number is an iTunes backup.
So what, if any, what items in this right-hand column, based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up to iCloud, and those are coming from an iOS backup in iCloud. Everything else is coming from an actual physical device.
Can you just take this down for a second, Michelle, and pull up 1675, please? Defendant 1675. And do you recognize this chart, Mr. Eckert?
Yes, I do.
Without yet getting into the contents, can you please describe generally what it is?
This is a chart that I prepared as a summary of my findings.
Permission to publish defendant 1675 is a demonstrative, Your Honor.
Any objection?
No objection.
All right, 1675, we publish this demonstrative.
Can you please describe in more detail what the three columns you can see in this chart represent?
Sure, this starts to give some detail about the particular evidence ID. So for example, A001 was an iPhone X of Amber's that was collected. A002 was an iPad of Amber's collected. A11, 12, and 13, slightly down, are three different laptops that were collected for Amber.
And do you see the IDS evidence number column?
Yes, I do.
Do you see the source type column
Yes, I do.
and the source details column?
Yes, I do.
Can you please describe what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence.
Hi, Mrs. O. Good morning.
And Michelle, can you please do a side-by-side of 1675 and 1671? Thank you. So, Mr. Acker, can you please describe the relationship between these two demonstrative exhibits?
Certainly. If you look at 1671, the one on the left, you can see in the fourth column the different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for example, the picture Neumeister referenced on page 24, or I guess that's the second one, there are equivalent versions or original versions of those that do not show the software EXIF metadata field of photos. Rather, it shows the original iOS version on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop, same with A0012 and 13. You can see this again with the next row that's visible at the very top. Neumeister identified a photograph on page 30, taken on December 16th, 2015. He was concerned about the EXIF metadata of that, showing the software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad. And it's not surprising to me that I found all these on all the devices, because that's how the Apple ecosystem works. It replicates your pictures or synchronizes your pictures across your devices when you take them.
Mr. Acker, you can take this down, Michelle. Do you recall Mr. Neumeister's testimony regarding what he claims of EXIF metadata modification?
Yes, I do. This is a completely hypothetical scenario. Mr. Neumeister never specified any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case were included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today made to a reasonable degree of forensic certainty.
Yes, they are.
No further questions, Your Honor.
All right, cross-examination, sir.
Thank you, Your Honor. Good morning, sir.
I have questions.
You've worked with opposing counsel's law firm approximately 20 times before,
Give or take, yes.
for more than a dozen years?
Those 20 probably would have been spread out over more than a dozen years.
Okay. As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
Now, I can testify to the ones that Mr. Neumeister identified with specificity.
Right, but there were thousands of photographs provided that Mr. Neumeier didn't testify about, right?
I have no opinions on any photographs that the opposing expert has no opinions on.
All right. My question to you, though, is as you sit here today, can you testify that all the photographs produced by Ms. Heard are authentic originals?
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
You'll agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph, right?
Yes,
Yeah, you just talked about it, right?
yes,
And you'll agree with me that the XF data of some of the photos produced by Ms. Heard reflect the use of a photo editing application.
no.
No?
I'll agree that they show the use of the Photos application, which is a sorting and editing application.
Okay, so what you were quibbling with is that it will both sort and edit.
That is correct.
Okay. Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered into evidence in this court. Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712 and Defendant's 713 next to one another? Your Honor, these have already been admitted, and I ask that we publish it to the jury.
Okay, if they're admitted, we can publish.
Can you see this?
Before he answers this question, before he asks this question, this is what I want to know, okay? If it is, as Amber states, that the way that her phone works is that the pictures that are taken are automatically added to the sorting editing app, right? Then how come all of the pictures that were presented, not all of her pictures over her phone, but just the specific ones? How come all of them don't have the same exit metadata? That's what I want to know. Okay, that's all I want to know, and I'm going to push play.
Yes, I can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right, we can take that down. Mr. Gibson, can you pull up plaintiff's exhibit 1308? This has not been admitted, Your Honor, and I propose to use it as a demonstrative.
Any objection?
Not as a demonstrative, Your Honor.
All right, be identified and publish the jury as a demonstrative.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no, no objection, Your
No
Honor.
objection, all right, it's in evidence then.
1308 is in evidence. Mr. Gibson, can you blow up the time, date, and file name? Sir, you just agreed with me that those two photos are different photos, correct?
I agree that they were visually different, yes.
Right. So they are two visually different photos that were created at the exact same hour, the exact same minute, the exact same second as each other, correct?
And that's what the daytime metadata shows, yes.
And the metadata shows something else too. They have the exact same file name, don't they, sir?
Yes, but that's not embedded metadata.
Right. How would you have this jury decide which one is real?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this particular field, but I think that's what even Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view, look visually different, correct?
I don't agree that they have the same identifying information. I don't see a software metadata field here.
The identifying information includes the hour, minute, and second they were taken, this picture were taken.
I see that.
No further questions.
All right, and just for the record, since we already have 712, 713 in evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just to keep the record clean, okay?
Ooh, Yvonne, that is an
Redirect.
excellent
Mr. Acker, you
question.
just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printed of a Word document. That's embedded into the file, and that traverses with the file wherever it goes.
And based on all of the photo metadata you have reviewed, do you have any reason to question the forensic authenticity of any photos Mr. Neumeister testified to for which you were responding to?
Can you repeat that question, please?
Yeah, based on all of the photo metadata you have reviewed, based on the photos Mr. Neumeister testified to, do you have any reason to question the forensic authenticity of those photos?
I do not.
Following your cross-examination, Mr. Acker, have any of your opinions in this matter changed?
They have not.
And is it still your testimony that the opinions you testified to do today are made with a reasonable degree of forensic certainty?
Yes.
No further questions, Your
All
Honor.
right, thank you. Sir, you can have a seat in the courtroom or you're free to go. All right. Did you want to approach this for a moment?
I don't know, you guys. What do you think? Here's my thing. Clearly, by that demonstrative that was just shown, okay, they're two visually different photographs. And the only way to have two visually different photographs is to alter the photograph in some way, shape, or form. That's the only way. If the photos were taken at the, if one photo was taken, okay, I'm going to say this right, because this is complicated and I can already tell my brain is like spinning. If you have two pictures that are taken, that have the same file, they were taken at the same time, yada, 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 right? Yet they're visually different. Something was changed about the photograph, the content of the photograph. It had to have been altered. You can't just have two visually different photographs. Something was altered. because it's even down to the second. Now, one could argue that one photograph was taken and then maybe the flash was turned on for the second photograph. But
All right, your
even in
next
that
witness.
situation,
Your Honor, we
the
would like to call Dr.
seconds
Don
would be
Hughes for the
different.
All right,
Champion.
Dr. Hughes.
Exactly,
Thank you,
Sugar
Dr.
Beet.
Hughes.
That's
Your mother's still here with us.
important.
Okay, ma'am? Thank you.
Oh, bruh. We're here with Dr.
And could you
Hughes.
please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours
And why are you here today?
to offer a rebuttal testimony to Shannon Curry's testimony of yesterday.
Now, Dr. Curry said you used improper methods. Would you agree with that?
No, I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis driven procedure where you're looking at a variety of different details and tests and external data to arrive at an opinion, and you're looking at the consistency across that data. There are 3 sort of sets of tests that we use as forensic psychologists, and I think that's where it seems that Dr. Curry seems confused. We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court for competency. If someone has competency.
She's
stand
not
trial, we have
talking
very
fast.
clear
I got
measures
him sped
that
up.
can track that legal criteria.
So we can
The
be
next
on,
level are forensically relevant instruments.
we can
And
be
those
caught up with the
instruments are
court.
not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure. So the malingering measure that I utilized was the MFAST, and that was the only malingering measure in this case. The third category are clinical assessment instruments, and those are instruments that are validated and well-researched and used in the clinical realm as we understand people's symptomatology and diagnostic and functional capacities. Those are things like the MMPI, the PAI, the CAPS, the TSI, because they are clinically relevant and they still
When we
give us very
started this
valuable
morning-
information to individuals who are involved in
Hold on a
court
sec.
case.
I don't want to
And the-
talk over her. When we started this morning, Johnny's team had 7 hours left, and Amber Heard's team had 1 hour, 16 minutes.
Reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. They're not in a courtroom. So they're well validated and well researched methods. What we also do is use a very different types of tests within that category. We use some checklists, some face valid checklists. We use some tests that are those broadband personality inventories. We use structured clinical interviews, and then we look for the consistency across those data points. And when we use different types of tests, it gives us information about the individual, how they go about these tests in these different modalities.
Now, Dr. Curry seems to suggest that Amber Heard tested the most extreme category in all of these different tests. Is that accurate?
That is-
Objection compound.
She didn't actually
That is
say
not
that.
accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time, this happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms that I determined was accurate and reliable.
And Dr. Curry also suggested that Amber Heard was tested very, very high, 98 percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things. So let's go through those tests. The first was the PAI, and that's that other broadband psychological
Objection
measure.
non-responsive.
I think it's very responsive.
Sustained.
Okay. Could you tell the jury about the PAI test that Dr. Curry
Yes, so,
addressed?
yes, thank you. So that's the broadband measure that has validity scales built into it that gives us indications about how the individual goes about the test. I told you last time that there was no evidence of malingering or exaggeration or feigning on that test. What Dr. Curry was talking about was this tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there were 2 other measures that we look at that to say, is this enough?
Oh, I
validation
know
for you to
exactly
consider
what
that as a serious
case you're
response to
talking about,
distortion? What Dr.
cement
Curry was
shoes.
saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity, and on affective instability. Those were the 4 scales that were elevated on this test. The borderline scale was not elevated on this test. And this test,
Objection, Your Honor.
Specific-
May we approach?
Yes.
You know what I find interesting about court cases? How different people interpret the same evidence. I've always found that fascinating. How two people can look at the exact same piece of evidence and have a completely different interpretation of the evidence. Is that the one? Let me make sure, because there's a couple of succinylcholine ones that I know, but isn't that the one with the horses?
Dr. Curry, let's move to the TSI 2. Dr. Curry testified about your findings on that. Did you agree with her testimony yesterday?
No,
Please
again,
describe why, explain why.
what Dr. Curry went back to, which is this 98th percentile, which I told you in the manual, all you have to do is read the manual. It says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she then is therefore not qualified to interpret it. That score,
Damn.
the one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of exaggerated symptoms where I can't further look at that test. Secondly, there are 3 scales out of maybe there's about 20, a little more on the TSI that were elevated. Intrusive experiences, that's when thoughts and memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out those memories and not think about them. And then relational avoidance, a way of having difficulty in interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for your interpretations. Do you agree with that?
No.
Please explain to the
So the
Cement
MFAS, as I
shoes.
told you last time, is a measure of malingering. It's the only measure of malingering that was done in this case. Dr. Curry did not independently administer a measure of malingering, and there are other ones that she could have done to augment her evaluation. And she kept saying something that MFAS is not for malingered PTSD. That's wrong on a couple of levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms that they have, and they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering measure to get a sense of how this person is responding to this evaluation. Now, what
Okay,
you do
I'm
is
going to
you take
look
those
into
3
this
tests
one
that I
because
talked
there's
to you
another
about,
one with
the PAI,
horses.
the TSI, and the MFAS, all with valid validity scales. You have greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report. That bolsters the methodology that I used. That in a study that had the PAI, the MFAS, and the TSI in the title of detecting feigned from bona fide PTSD.
So the
Thank you.
case
Now,
I'm
Dr. Curry
talking
also talked
about,
the danger assessment scale and suggested that
excuse
you had
me,
inappropriately
Elaine.
interpreted that. Do you agree?
So rude, Elaine. So the case I'm talking about, because I have to say it or I'll forget it. If I say it, I'll remember it. The case I'm talking about was a husband-wife situation where they were out riding horses, and the husband said that the horse threw the wife from the horse, and that's how she that's what resulted in her death. And it took a while, but it ended up being that it was succinylcholine. All right, so that's all I wanted to say, and here we go.
That's also incorrect.
Please describe for the jury.
Which I told you last time, the danger assessment scale has statistically validated risk factors for serious or lethal domestic violence. Those risk factors exist whether we go forward, we're sitting with someone in an acute setting and assessing them right now, or if we look backward and we look retrospectively about what factors may have been present in a case that indicated severity. That instrument is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been killed, a homicide has occurred in a domestic situation. They look at these risk factors to see what was there and what could be done.
All right. Dr. Curry also criticized your administering of the CAPS-5. Do you agree with her criticisms?
I do not.
Will you please explain to the jury?
So the CAPS-5, as you all have heard multiple times, is a structured clinical interview in determining PTSD according to DSM-5 criteria. On this measure, Amber Heard scored in a moderate range. She did not over-exaggerate on this test. She could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s, none above that. So she's scoring in the moderate range, which still has functional impairments. I mean, we don't want someone to be having moderate PTSD, but that's not an exaggerated profile or exaggerated response style of someone who's answering an instrument.
Right. And the last of these Dr. Curry referred to was the PCL-5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is.
I have a
as you
question.
said, it is a face valid instrument. It seems it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment. And that's what I did. I took what she wrote, what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms to see if they meet criteria for PTSD. That is something we do clinically, and I do in my office all the time. And yes, she did meet PTSD from that in January 2021.
Thank you. Now, Dr. Curry said you misinterpreted her test results. Do you agree with that?
Yeah, I agree that I agree that I interpreted them, that she misinterpreted them.
Okay. And please explain.
Yeah, so I said that before. My stance on the MMPI and how she interpreted it is, I believe, wrong, and I think most.
Objection, Your Honor.
All right.
That's the issue we just addressed.
I don't.
If you want to approach.
Okay, so here's my question, right? There are some tests that both doctors administered to Amber Heard, right? Things that she would fill out. Okay. So what I'm curious about is if
Now, Dr. Curry also testified that a
Elaine,
victim
you're
with
so
PTSD
rude.
has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
Oh, she said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form.
that's not what she said.
No, that is not correct. That is often actually a myth and misconception about individuals who are struggling with PTSD or trauma-based disorders. And I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling. They get up, they have to go to work and drop their kid off at school and go to the market, even though they're struggling with these symptoms. So I often talk about it as the sort of walking around with a 50-pound bag of flour on their backs, just sort of trying to get through the day, where sometimes that button's going to press play and the trauma is going to start activating in their head, and then they're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still have, impairments in other ways, but they go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the CAPS. Ms. Heard had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is, beholden upon them to accurately assess for intimate partner violence and sexual violence. And it's more important to assess for this sort of scientific understanding of what domestic violence is. So you have to assess for the physical violence, the psychological violence, the surveillance, the economic, the emotional abuse, and the sexual violence. That is not gratuitous. That is
Objection.
understanding.
Narrative.
All right. Next question.
Okay. Now, Dr. Curry suggested that you made a determination just based on personal opinion and just on checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests and reviewing a slew of documents in this case, and most importantly, therapy records and interviews, collateral interviews with therapists, using all that data. That is what a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
And just to remind, to make sure we're reminded here, you were qualified in this court, in this case, as an expert in forensic psychology, and specifically in domestic violence and in no, I just lost it.
IPV, Elaine.
And in violence, correct? Intimate and in trauma, correct?
But I believe
Objection,
it-
Your Honor, misstates the record.
If you want to ask the question again.
Yeah, I probably should do that. You were qualified I gotta find my note. You were qualified as an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case.
That's correct.
Okay. Now, do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do you still hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right, cross-examination.
Yes, Your Honor, but can we approach quickly?
Sure.
Okay, so the question that I want to ask is when the same tests are given to a patient, but given by two different psychologists or psychiatrists, are the questions the same on both tests? Because what I'm curious about is if the questions are the same on both tests, right? Then how would a person get two different scores? Which is really a question for Dr. B. So now that I've said it, I'll remember it and I'll ask Dr. B.
Good morning, Dr. Hughes.
Good morning, Mr. Dennison.
The last time you were here, I believed that you testified that you had diagnosed Ms. Hurd with PTSD before you gave the gold standard CAPS-5 test.
That's correct.
Right. And that diagnosis is actually reflected in the first of the disclosures you put forward in this case.
I believe the first disclosure was February 2021. And at that point, I had done 11 psychological tests. That's correct.
And your disclosure reads, Ms. Hurd's responses on the PCL-5 support a DSM-5 diagnosis of post-traumatic stress disorder with an etiology of intimate partner violence she experienced by a former partner. Remember writing that?
That's correct.
Okay. You just testified that you need to read the manual, right?
Yes.
Okay. Can we put up 1311 as a demonstrative?
Is it the manual? But see, this is the thing, Sam, these are tests that she does. So the way that Dr. Curry had it is that Amber was the one answering the questions herself.
All right, if you want to
Okay,
leave.
we approach.
She was the one doing the circling or the rating or whatever. And that's what I'm curious about. Now, what I want to understand is how do you calculate if the questions are the same and the answers are the same, then how is it that they come out with two different scores? That's what I want to know. Actually, what I'm curious about more than anything is what, if any, research did Amber Heard do when she met with Dr. Hughes or Dr. Curry? And did she meet with Dr. Curry first and then Dr. Hughes? Because what I'm curious about is, did she do some research to realize, because look, I'll be honest with you guys, if anybody ever goes to apply for a job at Walmart, all right, they sit you down at a computer. That's where you fill it out. I mean, you might be able to do it at home now. Back in the day when I worked there, you sat at the computer. And what they had were they had a ton of, they were really personality questions, right? And you would rate your answer with strongly agree, somewhat agree, somewhat disagree, strongly disagree, right? So the idea is that you would want to answer, because they really do ask you the same questions repeatedly. They just ask them in a slightly different way. So what they're looking for, this is what I've been told. What they're looking for on those tests as an employer is consistency throughout each and every answer, number one. And number two, that optimally, they don't want you to answer anything strongly. You can either agree or but you try to keep it in the middle. That's the ideal. Not the idea, but that would be the ideal answer, right? Is something somewhere in the middle, but mainly, but also consistency. So what I'm curious about is, is that the same type of test that was administered to Amber? That's what I'm curious about. Okay, that's all I want to know. Okay. Sorry.
They're getting the right one up.
Yeah, we got it.
What, for her to
Let's use
research how to
13,
answer the
13,
tests?
12.
Hey, Lycan
Okay.
Legion, I don't know.
That-
I don't think it would be
Any
illegal.
objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
Dr. Hughes, do you recognize what the National Center for PTSD is?
What it is?
Yeah.
Yes, I do.
And they publish the PTSD checklist for DSM-5,
That's correct.
what we've been calling the PCL-5.
Correct.
All right. And are you familiar with the document that's on your screen?
Yes.
Dishonest,
What is-
yes, but I don't think
It's
illegal.
The instruction manual to how to administer the PCL-5.
I'd like to move for the admission of 1312.
Any objection to 1312 coming into evidence? All right, 1312 in evidence.
Can we go to the second page?
And here's going to be the part where he busts out the manual and finds
blow up
that she did it,
The second
administered it improperly or
on the
some
right.
such.
The PCL-5 should not be used as a standalone diagnostic tool. When considering a diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g. the CAPS-5. to
Also a
determine the
good
diagnosis,
point.
Correct? That's what the manual says.
Like
Right,
smuggling
and this manual
Okay.
also says that this is a
dogs
screening instrument. So when you
into
do the clinical
Australia.
interviewing, you absolutely can determine diagnosis
So the
after
answer is
somebody
yes. The manual says you
still
the
need to use clinical
PCL-5
interviewing skills, which I used.
let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5 to determine a diagnosis, correct?
It does say that, yes.
Yeah, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical interviewing and 11 other psychological tests that supported diagnosis of PTSD and symptomatology consistent with PTSD.
Okay, you said that we should read the manual. Would you also agree with me that we need to read the directions?
Oh my gosh.
Sure.
Okay.
Yes, reading the manual is important and reading directions is important too.
1309 as a demonstrative.
Oh, yeah. Yeah, Lycan. That would definitely, yes, that would definitely be illegal. I think bribery, period, is
Yes, sir.
not just frowned upon. I believe it's also illegal.
Any
Like
objection
in
to
this
1309
setting.
demonstrative?
Not like bribing your kid to do their homework with money. That's legal, frowned upon, but legal. Okay, Sam, I gotcha.
9 and publish to the jury as demonstrative.
I also like how it's so easy for.
Doctor, do you recognize
Hold on.
the demonstrative that's in front of you?
Yes, but I didn't put the red lines on that.
No, I didn't.
Yes, I know.
Okay. So this, what do you recognize this as?
I recognize that we previously discussed this, and I told you that I oriented Ms. Hurd to a different time frame because she was already out of the relationship.
Okay, maybe we should back it up a little. This is the CTS-2 that you administered as part of this battery of tests that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale too.
And you'll agree with me that this test specifically asks, in front of every single question, how often did this happen in the past year?
Correct, and I
Right,
oriented
and
the
you know-
individual to
I
not
think
limit
it's
herself to the
correct,
last year to get an accurate assessment of the violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
All right. I'll move to strike the last part of the answer. Strike the last part of the answer. Thank you. Next question.
And you know that at the time that you gave this test to Ms. Hurd, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no,
time
ma'am?
frame in answering the questions.
Doctor, yes or no?
So, of course,
Okay, you knew she was gone for more than a year.
of course.
All right, let's look at another one of these.
Her team is just as reactive as she is. Have you noticed that? Her expert witnesses, they be
You talked about the danger assessment test.
getting
That's-
flip.
All right.
Flip's not the best word. They get fresh, is what I'm trying to say. They got slick mouths. They get defensive very easily.
Plaintiff's 1310.
Thank you.
Any objection to 1310 as
No, no.
demonstrative? Okay.
It's just something I've noticed. Doesn't negate the validity of their testimony. Just something I've noticed. Just one of those
Dr. Hughes,
things.
This is
They all
in blank
have to
form, but
see-
this is the
have in
danger
common.
Assessment test that you also gave to Ms. Hurd, correct?
I didn't give it to her. I filled it out based on the data that was provided to me.
Oh, so you asked her the questions and then you filled it in.
It was somewhat collaborative.
Oh, collaborative, was it?
Blow up the second full paragraph. It says, using the calendar, please mark the approximate dates during the past year. when you were abused by
Look,
this
stranger
person
things have
or this
happened,
person."
Lycan.
You didn't use any calendar, did you?
I don't think she
I did not
bribed her.
use
I
the
think
calendar
she did a
because she was
Google
already out of
search.
the relationship. As I said, these are static risk factors, so they don't change. So I
But these
orient her to the
exams-
time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that that you were supposed to look over the past year. And
That's
not the
one,
language?
no, that's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this
I
relationship.
didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test not only on the
No,
previous year,
asking you about the instructions.
but I'm telling you how the test is administered in clinical practice and in
And-
forensic
and-
practice.
And opposing counsel can come up and ask questions about it. I'm asking you about the instructions. And the instructions say, look over the past year.
Very emotional.
on this,
This
yes,
is
that
not a
says-
good
And you had
look.
actual knowledge when you gave the test that Mr. Depp was gone way more than a year before this test.
That is correct.
All right, let's look at more instructions.
Dr. Hughes is having a better hair day today than on her
12:47,
original day of testimony. There you go, Dr. Hughes. I'll give you that. That's a compliment.
Dr. Hughes, you recognize this one too, right?
Yes,
All right, this is the, what everybody calls the CAPS 5.
correct.
All right, can we go to the first page? Let's blow up the instructions. Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Can we go to the next, next?
This is the best. This is the way that you would want to handle
This is a page on scoring.
Witness
And we
like
talked
this,
about
though.
Last time,
Yes,
you score these tests by.
Pay attention,
frequency
Elaine.
And intensity.
correct.
And you'll remember that in every single instance that you were asked to fill in the blank about frequency, you failed to do so, correct?
That's not correct.
Oh, you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I
Where-
asked
where
you
it's
whether
relevant.
you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's page down. Let's keep going. All right, we'll stay at this page for a second. This is the very first box you're asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison. I had 88 pages of notes of what happened. It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review them. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
All right, but you
This is-
chose to put absolutely nothing in the box, the standardized box that said what happened.
You don't have to put it in the box if you have it somewhere else. It's not
Because
a,
this
it's
is not
not
a
a,
standardized test?
well, if it's not a research instrument that is used for research, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay, let's go.
But you're not
to the next
treating
page.
her, ma'am. This wasn't a clinical setting. Hold on a minute. I got to push pause
do
because
another
this I'm getting. So I just want to point this out, which I feel like I'm being Captain Obvious right now because this is obvious, I think, to everybody who's watching this. that this is the way that you would want to question or cross-examine an expert witness, right? You're going to want to question them on the results of their testing, right? And the method of their testing, right? Not spend 27 minutes going over dinner and drinks and takeout and who was at the dinner, who had the Moscow Mule. Wait, but we want to make sure we're clarified that it's a Moscow Mule and not a mule like the animal. Ha ha ha, Lane, so funny. That's yeah. Okay, that's all I wanted to point out because it gets annoying to me. I get frustrated. Oh, Lane, you're looking like a whole Easter egg over here, babe. Come on, get it together. All right, sorry for my outburst.
Let's look at item 4B4.
Yes, let's.
And I asked you whether you filled in the blank about frequency. And there's a blank in many of these.
Shmita, be in charge, okay?
Number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test.
Yes, correct.
No further questions.
All right, redirect.
Very briefly. Static risk factor, what did you mean by that?
Static risk factors are risk factors that don't change. It's maybe if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you have, the greater likelihood that somebody's going to have psychological consequences and symptomatology as a result.
And therefore you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the time frame in the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you want to have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You have to understand, the traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner
Objection, Your
violence.
Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages. I'm not asking her to give each of the specific events. She can describe the summary of it.
Can we come up?
Okay.
What is the difference between clinical scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
Objection compound.
Sustained.
Your Honor, when it's compounded, it's because it might be confusing to the jury.
Sustained. Next question.
Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test and research?
Objection, Your Honor, compound.
Overruled. Good.
Sure. So the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma and what the person has experienced. And why those boxes may be relevant in research is because, back in the day when I was a research assistant, I had to input that into the computer. And then they would maybe look at some of that data for the research study. So that becomes very important in research.
All right. Thank you. I have no further questions.
All right. Thank you, Dr. Hughes. You can have a
Thank
seat in the
you.
courtroom or you're free to go. Okay.
Thank you very much.
All right, ladies and gentlemen, let's go ahead and take our afternoon recess. Our morning recess. Let's take our 15-minute recess. Do not discuss the case with anybody and don't do any outside research, okay? All right, why don't we just come back at 11:05 then? All right, excellent.
All right, we're still behind, so we're in good shape. This break is going to fly by. All right, I'd like to speak to this exact point here. All right, the difference in the way that these two doctors testify is thusly. So, as rebuttal witnesses, I'm just going to go over the rebuttal, not the whole thing, because I already made a whole video outlining, do you know the Muffin Man? That's all I'm going to say about that. All right. So, when Dr. Curry was testifying yesterday on rebuttal, the way that she addressed the jury is, as I testified to previously, versus Dr. Hughes, as I told you already. You see, as I told you already, in and of itself is, it sounds like you're impatient, as if, why do I have to explain this to you again? It's off-putting. And somebody with as much experience, knowledge, and education as she has should know that tact is very, very important when you're dealing with human beings. And exactly, Allie. She talks as if she's annoyed. I already explained it to you once. Are you too daft to understand my first explanation? That is how it comes across. And this is what I was talking about with respect to the differences between the expert witnesses that testify on Johnny Depp's behalf and the witnesses that testify to on Amber Heard's behalf. Okay, the experts on Johnny Depp's team are very, very good at testifying. I think that both sides have of expert testimony. I believe their credentials. I believe their education. I think they're qualified to speak about what they're speaking about. The problem is in the delivery. The way that Johnny Depp's team comes across when they testify is much more approachable, much more reasonable. They don't seem to get as flustered. I do too. Listen, Lycan, I do too. I don't want to be explaining things 11 billion times to people. That's the truth. But I'm also not testifying in a trial. If I were testifying in a trial, I would explain it as many times as it was necessary to get my point across. And they get flustered. And what seems to be, and I really don't want to use this word, but I don't know another word to use right now because I'm really running on fumes, you guys. I've been doing these streams a lot and looking into other things on the side. And plus I have to, take care of myself. Like I have to have a relationship with the shower, soap and water. Those are important. Toothpaste, those kind of personal hygiene, plus keep the house clean, cook, things like that. But it seems that the way to that their trigger point or trigger seems to be if they feel that their knowledge, intelligence, or education or methodology, I really should say, is being questioned, even if it may not be outright being questioned. Her team's expert witnesses seem to get very, very defensive, very, very quickly and very, very easily. Yes, Johnny Depp's side is done besides their crosses and closing. They just do. And the thing is this is why I find trials fascinating, because it doesn't matter how intelligent you are. And if you're in in a trial setting, right? Just generally speaking, more intelligence would be better, right? However, if you cannot get what the intelligence from your brain out of your mouth in a way where the people that you are disseminating the information to can understand it, then what is the point of the intelligence? That's part of intelligence, in my opinion. Knowing how to effectively communicate is part of being intelligent. It's a different kind of intelligence. You got to have people skills if you're going to be testifying in a court. You have to break down and disseminate the information in the way that people can understand it. People that don't work in your field, right? That's hello. That's like the crux of testimony. And they just come out and they're just like, well, I mean, if you stick around some of my streams, I mean, you'll sometimes I stumble around. You know, it happens. But it seems to me that if I were an attorney and I were screening potential expert witnesses, I would be screening them not only for the knowledge and education that they possess, but also how effective they are at testifying, because that's very important. I mean, look at Dr. Spiegel, who is going to be the subject of no less than 11 billion memes, TikToks, shorts on YouTube. He already has been. I mean, he's fastly approaching, the 11 billion mark. At least he's got to be close. Maybe he's got 10 or 15 more. I don't understand what you're talking about, like, and you just said, well, I can't, just give me a second. Anyway, look at how his testimony went. No matter what it was that he testified to, how important the details were that he was testifying to, it was completely lost in the argumentative nature of the cross. And it was him being argumentative. Granted, the the attorney for Johnny Depp was asking tough questions, okay, but he just came undone. No, what I'm saying, Lycan, is that you should stick around my streams. I stutter around and have a hard time sometimes getting the intelligence out of my brain through my mouth, because my brain thinks a lot faster than my mouth does. And that's what happens. Don't be trolling me today, Lycan. Today's not the day. Okay, listen here, Mr. Man. We are on Thursday of what has been a very busy week for yours truly here. Okay. I don't recover the way I did when in my 30s or in my 20s. Takes me a little longer. Cut me some slack. Also, I'm upset with you because you didn't even bother to address the email that I sent to you with respect to the video. I was so looking forward to your feedback, and you did not give me any feedback because you didn't watch. So now we're broke up. Just so you know, unfriended, blocked, and reported. Just kidding. Can you imagine if I was like that, though? Yeah, Jen's 5 hour is still kicking in. It's actually not kicking in. I feel like I might. Let me tell you what happened to me this morning. Okay, 5:30. I was awoken by one Alice with that freaking battle cry that she does. So annoying because she has an actual, yeah, I could use a mega pint of some Xanax. So she wakes me up at 5:30 this morning, and she has a cute little meow when she wants to, but no. Today was the battle cry. And when that battle cry didn't get the initial and immediate response that was required of me because I was asleep, it was followed by the cold nose on the eyelids. So that made me have to get up. And I wasn't ready to get up. It was 30 minutes. She does this to me once a week, always 30 minutes before the alarm goes off. 30 minutes. I'm telling you, I love her to death, but I am firm in my belief now through research and investigation and personal experience that cats hail from they are the original Sith lords. I'm telling you, I promise you, this is fact. It's probably in the Bible somewhere. It's just fact. So this is what I went through. So I didn't get my sleep out. And then I have to hear Dr. Hughes over here, bumbling around. Not, she didn't bumble around. That's not fair. She just sounds irritated, like they're bothering her at work. You're at work, ma'am. You're getting paid for your testimony. So could you please speak less defensively to the jury as if that you're bothered by the fact that you have to be explaining this to them? You knew that Dr. Curry was going to have a different opinion, right? You had to have expected that you were going to be called as a rebuttal witness, or maybe you were just hoping that Elaine would spend a ton of time sighing and flipping through papers and not turning her mic on when she raises an objection and would run out the clock and you wouldn't be called. I don't know what you thought, because you just acted so bothered. Coolest reviews. Wouldn't a Sith, because they don't come from planet Earth, be alien? So aren't we really arguing the same point? An alien overlord, a Sith overlord. Either way, my life is run by something that weighs 11 pounds. Sorry about that, Alice. But she was in the bathroom the other day and she was standing on the scale, so I pushed the button and Alice weighs 11 pounds, 7 ounces. But we don't judge because round is a shape, isn't it, babe? Yes, it is. You want me to just speed it up? Let's just get to it. I'm about 3 minutes. There we go. Now they should be back any minute. I don't know, coolest reviews. Like, I think the Jedis are great. They help out others. They're not selfish, all those things. But did you know that one of the Siths had so much knowledge of the Force that he could influence the midichlorians and create life? That's kind of cool. Plus, there's the Vader throat hug. That's kind of a cool power. Electricity from the fingertips. I gotta say, also kind of a cool power. And they can move stuff too. I don't know. I'd like to be the type of person that says, the Sith are clearly bad. They just want to run the show and rule everyone and subjugate everyone, and therefore they're bad. And the Jedi, they're great, and that's who you should want to be like because they want to help everybody. I don't know. Subjugation. I don't want to be subjugated, but I mean, come on. Having unlimited power. Wouldn't that sounds fun. I don't know. Just think about the words unlimited power. That Doesn't that sound much funner than, you know, what is it? Fear leads to hate, hate leads to anger, or no, what is it? Fear leads to hate, hate leads to anger, anger leads to suffering, or is it a different, is it backwards? But you know what I'm saying? That doesn't sound as fun as unlimited power. I'm sorry, it just doesn't.
All right, are we ready for the jury? Yes, yes, sure.
Clearly, the Jedi are never going to ask me to be their spokesperson for recruiting. But somehow I feel like that's fine because I feel like the Sith would pay better, quite frankly. Yay, Sugar Beet. I'm so glad that you have your you have a new roof. That's wonderful. Wonder who they're going to call next. I wish also that there was like a little clock in the corner that started at 1 hour and 16 minutes and we could know where we're at now, like a play clock, you know, like in sports. You know what, Allie? 79. I kind of think she doesn't. Oh, thank you, mi amor, Michelle. That was so sweet of you. Exactly. Coolest reviews. They're very uppity and acting as if they're working in the best interest, but really they are just doing whatever they want to do because who are they to decide what's in everybody's best interest? Thank you. Boom. The loud ticking one. Ah. I have found it really interesting, Sugar Beet, because it's like I don't know about you guys, but I've learned a ton of stuff about civil litigation that I didn't know before at all. And I'm really glad that I've learned it. Like I think learning stuff is good. You know, I'm all for knowledge. I do believe GI Joe, knowledge is power. I believe that. I think that's an accurate statement. Um Now that song's gonna be in my head. G.I. Joe, a real American hero. G.I. Joe is there. See? That's what happens. I'm 45 years old. Do you know how long it's been since I've ever seen a G.I. Joe cartoon? At least 30 something years. But here we go. I still remember it. Useless information. Stored up in them 11 billion tabs. Excellent point. Coolest reviews. Absolutely. They cheated. Correct. And then they controlled what was going to happen to him for the rest of his life. And he had to sneak around behind the Jedi's back because he was in love. Why should love be a secret?
All right, thank you, ladies and gentlemen. You may be seated. All right, your next witness.
Your Honor, defendant calls Amber Heard.
All right.
Oh,
Stand,
here
please.
we go.
Yes, ma'am. Water. All right. Thank you, ma'am. And just a reminder, you're still under oath, okay?
Are you
For sure.
remembering
Thank you. Thank you. All
the
right, your
Whitney's
question?
testimony about the perfect ass? You wanted to give Johnny just
Amber,
one
just
more
to
look of you
orient
walking away?
And the jury, at
Well
this
played, girl.
time, we're in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine my questions to that, okay?
All right.
Did you not speak to her this
How
morning?
have you suffered publicly as a result of the Depp-Waldman statements?
Objection, speculation.
Overruled.
I am harassed, humiliated, threatened every single day.
TikTok has not been kind. I'm not going to lie.
Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave, and they tell me that.
Oh, no, that's too far. I'm going to have to agree with
Johnny.
that, Amber Heard.
Threatened, promised me that if I ever left him, he'd make me think of him every single day that I lived.
Objection, Your Honor, non-responsive.
I'll sustain the objection as to that. If you want to ask the question.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir.
Unspoken rules
not hearsay.
Overruled. Go ahead.
about how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow for me not to have a panic attack. or a
I feel
triggering
like you
event
had rules
where
before,
I
but
relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing, smiling, and making snide jokes. This is horrible.
hold up,
This is painful.
ma'am. Please don't make me do it, Miss Heard. Please don't make me make Shmita download your testimony so that I can clip it into a video set to hilarious GIFs, commentary, memes, and a killer soundtrack to prove you wrong. Please don't make me do it, because I will. You have been snickering. You have been smirking.
And this is humiliating for any human being to go through. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people to do on his behalf when he himself
Objection, Your Honor,
couldn't do
lack of
it.
foundation.
Torture me every day.
Speculation.
I'll sustain the objection. Next question.
Amber, how have the Depp-Waldman statements impacted your ability to do charitable work?
you know, the only reason that people like Dr. Curry can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have interests is
Objection,
because I'm not,
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Overruled, good.
it's because I found a solution to that pain. I woke up every morning
Was it
with panic
Adderall?
attacks
Oh,
and
cocaine?
trauma until I realized I could do something with it. So to answer your question, Ben, I was able to turn the things that I've lived through, my pain, my life experiences, into work, into action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others.
But not actual
to
money,
bring light to
which
these
you
issues,
pledged?
to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy, if it gives a voice to someone who doesn't have it, but I now, as I stand here today, can't have a career. I can't even have people associate with me because of the threats and the attacks that they have to endure
Objection,
when they are.
non-responsive.
And I can't do my charity work.
Sustain the objection.
You can't
Amber,
write a
other than
check.
the threats that you've described, what other
That's just
threats
an
have you endured
obligation.
since the Depp Waldman statements were made?
Bruh.
I receive hundreds of death threats regularly, if not daily. Thousands since this trial has started. People mocking my testimony about being assaulted.
I mocked your B testimony. I sure did.
Objection, relevance, non-responsive.
Goes to
Overruled.
damages. You can continue.
It's been agonizing, painful, and the most humiliating thing I've ever had to go through. I hope no one ever has to go through something like this. I just want Johnny to leave me alone. I just want him to leave me alone. I've said that for years now, and I thought he would after
Objection,
2020.
non-responsive.
All right, I'll sustain the objection. Next question.
Bruh, Camille, I think Camille
What
might
do
be
you
able
hope
to
to
give me a
reclaim
run for my money at
after this is
Mario
over?
Party in the button pushing event. I'm pretty quick, but Camille might be
Protecting
quicker.
The secret that I did for as long as I did has taken enough of my voice. Johnny has taken enough of my voice. I have the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American to talk about what happened to me.
You do, but
own
you
my
have to
story
tell
and
the
my
truth.
I have that right.
You can't just be making stuff up and adding
I
extra.
hope to get my voice back. It's all I want. And I've said that from day one.
Thank you, Amber. I don't have anything else.
All right, cross-examination.
Oh, they've got plenty of time, Amber. Yikes.
Actually, Your Honor, may we approach?
Yes.
I'd like to see that tissue, Amber. Let me see if there's a moisture from tears. Not snot. Snot doesn't count. Here's the thing. She's not wrong. All right. Victims deserve a voice. Victims should be able to tell their story. And she should be able to talk about her relationship with Johnny Depp, but she should be telling the truth about it. Not exaggerating, not making stuff up out of whole cloth, not inventing scenarios which didn't occur, being honest about it, being completely honest. about telling her story. If you're going to be completely, in my opinion, being honest about telling your story means you tell the whole story, all the things, what you did. That's the only way that it works. You can't just be making shit up. You cannot end a violent encounter with, my dog got stung by a bee. It doesn't come across as genuine. Oh, today y'all we're on the yellow drink. We ain't on that purple stuff, and no mo. Well, right, Rarity. I mean, her voice was not stolen from her. You know who we haven't heard from that a lot of people would love to hear from, who we can't find, who doesn't have a social media presence, a presence at all. She doesn't get mail. Nobody knows where to give her mail. None of that stuff. Shelley Miscavige. What happened to Shelley? You have a voice. You were never silenced, Amber. The problem is that what you were saying with your voice didn't match the evidence. That's the beef people have. Hi, Amelia Sparkles. Who has caused you to miss like the last 2 hours? Do I need to write a note? Do you need a strongly worded letter? No. Why would I say NK, Shmita? Look, all roads do not lead back to Watts, Shmita. We've had this talk before, babe. Now, you know I lay you more than my luggage. But all roads do not lead back to the Watts. I hate that island. Stupid island. I met some cool people on that island, but the island, ugh. Exactly. Oh, I'm sorry, Amelia, but I can't write a strongly worded letter to a 5-year-old. I'm sure that would be frowned upon for sure. I mean, I'm capable of writing a strongly worded letter to a 5-year-old, but I shouldn't write a strongly worded letter to a 5-year-old. I mean, sure. Sure. Lying and crying are, I would imagine, some of the inalienable rights that exist in that our Constitution is talking about. But again, I have the right to strongly, vehemently disagree and make some hilarious yet accurate observations. Those are my inalienable rights. You're not wrong, Shmita. I will then find the reason why the 5-year-old is right and you were wrong. I've done it like 11 billion times. That's why. Longest sidebar ever. Again. I'm having a hard time getting comfortable in this chair, and I really want to turn on the little massagey lumbar pillow, but I know if I do, it's going to make my voice be like, and I think my voice is annoying enough without adding extra sound effects to it. I see. Is her sister's name Whitney or Whitley? Regardless, I see sis found the hairbrush and the curling iron today. Well played, ma'am. Now that you've met the brush and the curling iron, let me introduce you to two friends that I see regularly, soap and water. Nicole, no, I don't think that would be Amber Heard's mom, as Amber Heard's mom is no longer living. I don't think anybody poo-pooed in her Fruit Loops. I don't think she got name brand Fruit Loops. Amber probably makes her get like the Malto Meal store brand Fruit Loops, the generic Fruit Loops. She doesn't get to. No, don't be sorry, Nicole, because I've made that mistake myself by referring to the mom and forgetting. Yeah, it happens. No, Amelia, she has not gathered any more ground. She has managed to gather up some snot-filled uh, Kleenex. That's about it. Still hasn't been able to wrangle up some tears, though. And I like how she talks about her work, Aquaman. Amber, listen, I don't want to be the voice of, well, yeah, I love to be the voice of reason, and I hate to be the bearer of truth. Just kidding. I like to be the bearer of truth too, because I don't know any other way to say this. Aquaman was done in what, 28, 18, 19, somewhere in there. We're in 2022. You are like the Al Bundy of acting. You're still reliving your touchdown at Polk High from 1972, okay? As if that was your most only best memory and accomplishment. And I need you to zoom into this decade, ma'am, recent years. Let me just Google out. Make sure, check the maths. I've searched this 11 billion times. All I have to do is hit A and Q. Yes, 2018. Well, I watched Aquaman and I'm a grown woman. And I'll tell you why I watched Aquaman. It sure wasn't for Amber Heard. I wanted to hear Aquaman. I knew that Jason Momoa was going to make Aquaman cool. And that's just the truth of it. Nobody gives a rat's fat kneecap about Aquaman. What cool powers does he have? Brute strength? Batman has that. So does Superman. Cyborg has it. Now, granted, Batman's is bought, less to do with an actual superpower. His superpower really is that he's just rich. But what can Aquaman do? He can't even talk to fish. He even says so in the movie. Well, he says it in Justice League. He says the water does the talking. I just wanted to see what they were going to do with the character. I was invested like in Legion, and I have watched Jason Momoa in a lot of things. I would imagine that they hear a little bit of it, Amelia. For example, today, as part of my research and investigation, after we end this, I'm going to do a compare and contrast between the two Justice Leagues, the original release and the Zack Snyder release, because it's obviously 2 more hours. And there was testimony about the way that Zack felt about Amber Heard and specifically her chemistry with Jason Momoa. And so I'm curious because the re-release is the way that he wanted the movie, with no compromise to like Warner Brothers or anything. It was his way. So I'm curious if he cut her scene down, even if he paired her scene with Jason Momoa in Justice League down even more. Also, I just like Justice League, so it's okay for me to do this type of research. Like, put in timeout like ever in her lifetime? Like her parents used timeout as an effective disciplinary tool? Or I don't know what you mean. I need to watch Frontier. I want to check. I have a whole list of movies like in that I want to watch. All right, coolest reviews. It has been fun. Thanks for coming. Thanks for showing support. Appreciate ya. Is it? Why am I thinking it's a movie? What is wrong with me today? Maybe I need a jar of cocaine. Just to have, not to use, just for a display. Maybe it would be inspirational to make me pay attention. Oh my God. Let me look it up. See where I can watch it. Oh, it's on the Netflixes. Okay. I must admit that sometimes when I'm scrolling through the Netflixes and I be seeing suggestions, sometimes I'm not wearing my glasses when I look, and so it's hard for me to discern what's a movie and what's a TV show. So thank you for educating me today. And I can see you're on the path of helpfulness today. I'm glad you woke up and chose to be helpful today. Good for you. Thank you. I appreciate that. I feel like you like to help. I feel that you enjoy helping others, and I feel that that's one of the qualities about you that goes unappreciated, that people don't unappreciated, that people don't notice, that you can be helpful. Nothing. Oh, that's not true. That's not true. Apparently, you're a giver. I can tell that. Apparently, and this I don't want to joke about, so let me be serious for a minute. She said that she gets death threats, and that some of those include putting her baby in a microwave, and that is absolutely cruel and disgusting. And I cannot believe anybody. I mean, I recognize that there's people that have no low is too low for them. There is no line, and I just feel like that's ridiculous. Just
Ms. Heard, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
huh?
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That is correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park, Morgan Knight, on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar.
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that
Yes,
Johnny's
other than a light
employees
fixture. That was
testified
the
to
only
my
thing that was
closet
broken,
being
right, Ms.
rearranged
Heard?
and things
Ms.
like
Heard,
that.
the only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being rearranged.
Your Honor, I'm going to move to strike everything after he summed it up, that it was a light fixture, as non-responsive.
She answered the question, Your Honor.
Overruled.
In the security guard testimony, Your Honor?
I'll allow it. Go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous and Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That is incorrect.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-party TRO on May 27th, 2016. Do you remember that testimony?
I apologize. I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing the
Objection. Your
TRO,
Honor, this is not
we had
responsive.
no reason to
Move to
believe the
strike.
press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can, and Ms. Vasquez is misrepresenting to her what she testified to.
I'll strike the last part as non-responsive.
Honor.
Just if you could just answer the questions asked. Okay, thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up. In case. And
You
I'm
actually
glad
had
I did.
alerted TMZ that you would be filing a TRO against Mr. Depp that very
No,
day,
I did
didn't
not.
you?
No, I did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I
we
never
heard
did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yeah. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence wants that?
Now, the video of Mr. Depp beating up some kitchen cabinets, you admit that you took that video, correct?
Yes, I did.
And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify about this video as well yesterday.
Yes,
Didn't
what
you?
say
Yes, I
you?
did.
And you heard Mr. Tremaine testify that TMZ received the cabinet video the same day you landed at LAX. Yes?
I don't know if that's what his testimony was. I'm sorry.
You heard Mr. Tremaine testify that the cabinet video was posted 15 minutes after TMZ received it. Yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible because
you
it didn't come
heard
from me. I was
Mr.
flying.
Tremaine
So I
testified,
know that's incorrect, is what I mean to say.
another liar on the stand.
I just know that that's incorrect.
And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
The cabinet video you filmed of your then husband.
How-
Yes?
The copyright ownership of that is news to me. I learned that yesterday.
It's the cabinet video that you captured of your then husband. Yes?
That is correct.
So
I
then
did
how
capture
could
that
they be
video.
the copyright
Cabinet video.
owners?
The same cabinet video that was released the night before you were deposed in your divorce. Yes?
That's correct.
You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that that you have seen is complete.
Right. But the one TMZ got the day before your deposition in the divorce was incomplete.
I don't know. I haven't seen it.
He testified
It's
that
your
the beginning
video,
portion of
you
the video where you
maniac.
set up the camera. That wasn't included in the video that TMC received.
I don't know.
Move
what
to
video
strike is
TMZ
I'm
inappropriate
talking
and
about Mr. Tremaine's
unprofessional.
testimony, Ms. Heard. Let's just
So you're
focus on
asking me to
Mr.
repeat
Tremaine.
his testimony?
No, I'm asking you if you recall hearing him say those words to this jury.
Yes,
Under
I
oath.
heard his testimony. We all did.
And he testified that the end of the video where you can be seen smirking. I know you testified earlier that you haven't been smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with that.
Was also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You
That
edited
video
out
did
the
not come
portions.
to me. I
Ms.
mean,
Heard.
come from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMC.
You're very wrong about that.
So
If
that
I
only
wanted to
Mr.
leak
Depp
information, I
looked
could have
bad.
done it in a more effective way, a lot sooner and a lot more.
Because you
I
knew
was
exactly
living
how to
with
do
a
that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
More effective than TMZ?
But you
Girl,
testified
bye.
earlier in this trial that you didn't know how to leak things.
I
Remember
don't.
that?
So then how could you do it more effectively if
edited
you
that
don't know how to
video
do
before
it?
You gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
Your face says it differently. Your face says busted
I'd like
big
to show
time.
you,
Yeah.
a picture from that's already admitted into evidence. It's Defendant's Exhibit 799.
Shmita, you're in charge again.
This is you at the courthouse on May 27, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes.
Jody Gottlieb is your publicist.
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316. This is a picture of you and your friend Rocky Pennington, right?
That is correct.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
All right, 1316 in evidence. You can publish to the jury.
This is a picture of you on May 28th, 2016, right, Ms. Heard?
I don't know when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this image was taken. I did not take it.
There's no bruise on your face in this picture, is there?
Again, I don't know when this was taken. And also I'm outside. I was obviously wearing makeup. I have no idea when this was taken. So I have no idea if I can
Let's
speak to
refresh your
what
recollection.
bruise you can see
Let's
or not.
refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness? This is an article dated May 30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that.
And the article is entitled, Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor. That's inconsistent from the way you treated all of these.
I'll sustain the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Miss Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 in evidence, you can publish.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup as per usual.
Let's zoom out of that picture for a moment, please. Thanks, Tom. That's Josh Drew in this picture, right?
Yes, that's correct.
And Miss Pennington
That is correct.
in there too? Ms.
That is correct.
Pennington submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes. Mhm.
Ms. Hurd, I'd like to show you Defendant's Exhibit 512, which is already in evidence. You've seen this photograph before, right?
I have.
On the second day of your direct testimony, you testified that this was taken in the downstairs of the main apartment on December 15th, 2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident. Yes?
I'm not quite sure from what incident this is when I see this photo in a vacuum without context.
Let's give you that context. Can we please, thanks. I could have day 16 trial testimony. Your Honor, may we approach?
All right.
Could you please turn first to page 4585?
Sorry, one sec.
Specifically starting on line 16, where it says, let's talk about December 15th, 2015.
You said 458, I'm on 4485, sorry. You said 4585.
4585.
Pardon.
Line 16. Line 16, where it says, let's talk about December 15th, 2015. Do you see that?
Yes.
And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12. 4603. Starting at line 12 and going on to page 4604, line 4.
Okay.
And do you see that you testify that Defendant's Exhibit 512, which is on the screen,
Yes,
is a picture of the downstairs of the main apartment?
that's correct.
And the main apartment is Penthouse 5 in the Eastern Columbia building, right?
No, well, depends on what, the main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet.
Got it.
Mezzanine office was in between.
All right, so it's your testimony that defendant's exhibit 512 reflects damage to the penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in
in my
relation to that incident.
sorry, go ahead.
In relation to that incident on December 15th, 2015. This exhibit, defendant's exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial
No,
picture of a
Ms. Heard,
floor,
you didn't just
so
look
I
at a
can't.
picture. You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually leave out defendant's 512 and please pull up defendant's exhibit 725, which is already in evidence
Thank you.
in redacted form, Your Honor.
All right, thank you. You can publish.
Just side by side. You've seen this photograph as well, right?
I have.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless you remove the metadata you've covered up, we could then tell. If you
I didn't cover it up, Your Honor.
Could we
Your
unredact
Honor
him so
did.
we could get context?
That's how it's in evidence.
That's how
All
it's in
right,
evidence.
Next
Well,
question.
the metadata next to it is so that.
Ms. Heard,
to avoid this
Ms.
sort of
Heard, there is
confusion.
no question pending, and I would appreciate it if you wouldn't be making argument to the jury.
Sorry, I
It's
thought you had
inappropriate.
asked me about it.
No, I didn't ask you about anything. Let's look at your direct testimony from the third day.
I mean, these are your pictures, Amber. Sorry, I didn't mean to cough in y'all's ear. Hold on.
Yes, ma'am.
Well, thank you, Amelia. I like that word. I like a lot of wrong words. Bigly, 11 billion. Googles.
Let's turn to page 4750 in day 17 transcript.
Sorry, can you repeat that?
4750.
Do you need a crayon? Help you remember? Want me to write it down? Just kidding. That's mean. See, Amber, I can rage and regret too.
Specifically line 16. Do you see where Ms. Bredehoff asked you to describe to the jury what took place on May 21st, 2016?
I see that.
And do you see that your testimony
At least.
is reflected about May 21, 2015
Yes,
that follows? Okay.
yes.
Now let's turn to page 4804 at line 14. 4804.
You're good, Sugar Beet. This ain't a spelling bee
Starting
in
at
here.
line 14
This ain't school.
Yes.
We don't take attendance
through
and we don't have spelling
4805,
bees.
Line 4.
I was
Going
tagging
to
poor
what line?
Savannah
Line 4.
wrong
at
like 3 times before I even
4805.
realized there's no H at the end of her name. So
Do you see
The
that you're
word don't
testifying that
judge.
defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in Penthouse 5?
That's correct.
Okay. And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
that's
So which is it?
correct.
Which one was taken on December 15th, 2015, or May 21st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of a spilled wine on a floor, and I'm supposed to know off the top of my head when you
No.
live through 5 years of this stuff? I don't think so. That's not how that works.
Okay. Thank you, Tom.
I'm sorry, but that was funny.
Ms. Heard, at the beginning of your cross-examination last
Ron, may
week,
we approach?
Yes.
Why are we approaching Rottenborn? Now, to be fair, I'm not sure that I would be able to know when a picture was taken in that context. However, I have fought in like 3 different weight classes, so if I were in the picture, I could give you I could kind of give you a general idea of about what year it was based on the level of trouble on my person.
All right, ladies and gentlemen in the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right,
Ooh,
your next
everybody got in trouble.
Ms. Heard, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell
She
the
needs a
judge,
Shemitah
tell the
for a
world
hall
that he is a
monitor.
victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world
But that's
that
not what
he's
you
your
said.
victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that. at the
That's
time.
not true.
signed his name
He's
to
on
it.
the audio
You
saying
didn't
that you
expect as many
punched
people
him.
to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you never assaulted, actually, strike that.
Yes.
When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So
It
you
is
think
clear
Ms.
by this
Moss
courtroom
needs
how
to
many
come
people
out
will
of the
do that.
woodwork to testify for Mr. Depp?
Oh, God.
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course, I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. Is I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
I know
favor
that
and
firsthand. I've
risking
lived
jail
it.
time for committing perjury?
Excuse me? I didn't hear your
You
question.
didn't hear
Excuse
my
me?
question?
Ms. Vasquez, if you do
Curry-
mind, please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom
I have
for a
seen people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard
Huh?
Johnny claim that.
You didn't expect
Johnny
Keenan
doesn't.
Wyatt.
Johnny has never
Ms.
actually
Heard.
said that.
Ms. Heard.
What?
And
I think the
Ben
jury
King,
can,
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to just come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp.
Something you've been
after
incapable
what
of
you've put
doing.
him through, and so many others with your lies.
I
Same.
relate to Isaac because he and I are
There's
the
no
only
further
ones who have
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right, redirect.
Actually, Miss Heard, Isaac is the only one who's cried on that stand. You didn't cry.
Thank you, Your Honor.
You made crying
Ms. Heard, if
noises.
Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him from crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake injury caused by Mr. Depp?
No,
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
no, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection,
there's so
lack
many-
of foundation.
Overruled.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years, this has been going on. And I
I'm
have
done with you
pictures, we have
today.
texts, we have everything. Normally you don't get this amount of evidence. That's what I was pointing out to Johnny. It would be crazy to try to challenge this in this way. It's crazy. It's easy to not know the context of a picture of spilled wine because there are so many more important details, pictures.
I'm going to
And
stop
also-
you right there, Miss Heard, just real quick. I don't know if she's aware of this or not, but I'm sure you guys are aware of this as you guys all like true crime. The truth of the matter is that in many, many, many domestic violence cases, when it comes to time to prosecute, the victim is often put on the stand and often grilled about the lack of evidence, the lack of photographs taken, the lack of reports, the lack of witnesses coming forward who will testify that he or she told them that this person is abusing them. That's the truth. But okay. That's all I wanted to say. So you were with this man for all of this time and you thought that what? You should just be taking pictures of damage all the time from day one, minute one. Get out of here.
So much I didn't photograph, so much I didn't have the presence. of
Objection,
mind to document.
non-responsive.
I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically,
Yes,
verbally,
yes,
emotionally,
yes,
psychologically?
yes.
How did the threats that Mr. Depp made against you individually years ago resemble what you've endured as a result of the Depp-Waldman statements?
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would ruin me, that he'd ruin my career, he'd take my life from me. Death was the only way out. And if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up, that revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block him.
Objection, Your
block me
Honor,
from
lack of
working.
foundation, speculation, hearsay,
all in
non-responsive.
I'll sustain as to non-response.
Ms. Heard, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Those are
Objection, Your
just-
Honor, lack of foundation.
How could Amber have possibly known about the
overruled.
global humiliation? That text was
those are
not
just
sent
an
to
echo
her.
of what I'm living through today. It's like what I'm living in right now. What you see in this courtroom is an echo. This courtroom and the other courtroom he dragged me into to do the same thing again. That's just an echo of the violence and the abuse that I suffered within our relationship. the campaigns to have me fired, the blocking me to try to ruin my career, the threats he's made to humiliate me globally are being lived out in real time in front of you, ladies and gentlemen, for the past 6 weeks and for the whole world since our camera's here.
No further questions. Thank you so much, Amber.
All right, Ms. Hurd, you can have a seat next to your attorneys. If I can have the attorneys approach.
I don't know, you guys. I'm just, there's some stuff that doesn't sit right with me about her testimony. And I'm wondering how the last bit, not direct, but redirect. I wonder what, if any, that is impact that is going to have on the jury. I kind of am thinking that they're over it at this point, and that no amount of emotional pleas from the witness stand, and to be fair, really by either one of them, by Johnny Depp or by Amber Heard. I think that yeah, what if any, you like that? um I feel like I feel like the jury is sort of at this point done with the emotional testimony, and is going to look at the evidence. And I wonder if the jury, when they go back to that room to deliberate, see, they've been talking about how they're going to give the jury the evidence, right? So what's going to happen is the jury will get a clean laptop, meaning there's nothing on it except for the pictures, the video, all the evidence in this case, right? So for them to look at. And I'm wondering if the jury is going to notice that that text was incoming and not outgoing. I wonder if they'll notice that, because a lot of that was a huge deal was made out of that text.
Your next witness?
Your Honor, the counterclaimant Amber Heard rests.
All right, thank you, ma'am.
And so
All right,
does
ladies and gentlemen, you have heard all the evidence.
Easter
you're gonna hear in this
Elaine.
matter. What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a good restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m. and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go. Tomorrow, I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday or Monday, because Monday is a holiday. I would like to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the room at the same time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go. Okay? So have a good evening and we'll see you tomorrow morning. Okay? Do not discuss the case with anybody. Don't do any outside research.
I mean, they could sugar bait if they wanted to. Yeah, they could remark. They could make a comment on it. Yes, they should. Absolutely, they should.
We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also I want you to look through all your exhibits and make sure we're all on the same page before you leave. I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50.
So I'm curious then, will that be televised? Will this part of it be televised? I don't know. Kind of curious. Wow. I know. I know, Sarah. Like, this is how I'm feeling right now. Great. Now, what the F am I supposed to do? Ah, the text. So, hang on a minute. Let me check my files so I can read to you this text. Um, in its totality, and try to remember everything about the text. Hold on just a second. Let me find it. All right. This text is between Stephen Deuters and Johnny Depp, and Stephen Deuters is or was Johnny Depp's personal assistant at the time that this text was sent. It was sent on February 22nd, 2017, and it was read on February 23rd, 2017. And I'm not going to get into the timestamps because it's that UTC and you have to take away 8 hours, and I'm not mathing because that's not the important part. Incoming. Right? 3 exclamation points. Exactly. 3 exclamation points. Molly's PUSSY is rightfully, oh, this is in all caps, rightfully mine, 4 exclamation points. Should I not just bust in and remove its hinges tonight? 3 question marks. The next one is incoming. I want to change her understanding of what it is like to be thrashed about like a pleading mackerel. All caps. I need, period. I want, period. I take, period. Why? Who told Shmita that she could drop her YouTube link? If I were a pettier creator, just kidding. Can you imagine if I was like that, though? Y'all go check out Shmita's video. She did a good job on it. That's the text. Do mackerels plead? I assume he's talking about flopping around like a fish out of water because a mackerel is a fish. I find it interesting also, given the fact that Johnny Depp played a pirate, right, that he uses a lot of sea references, you know, like he fully immersed himself in the pirate experience. I mean, maybe they plead with their eyes. I don't know. I know they don't plead with words that let's call Aquaman. If there's any pleading that the mackerels are doing, Aquaman can surely translate, right? Except for he doesn't talk to fish. I feel like in the comics he does talk to fish, actually. I think that he does. I'm also amused by the other text that I am sure I have the screenshot. I don't think I actually have the screenshot. I'm sure I could find it if I had to, but where he refers to Elon Musk as mollusk. Again, another reference to the sea. I'm sorry, Amelia. I'll be nice. I didn't realize you were trying to eat. I know it's lunchtime for us on the East Coast, and I have my stomach is eating a hole in my back, but I'm still working on those last little bit, those vanity pounds. They're not, let me be honest. It's a little more than vanity pounds. Probably like I don't know, 7, maybe 10 pounds I still want to lose. And so you eat for both of us, Amelia Sparkles. I'll be dining on air. It's not a healthy thing to do. Just kidding. I'll probably have something, but I got to, whatever it is, will be small because, you know, I haven't been working out. And you know how I feel about the whole diet thing. The way to lose weight is, you know, put more calories out than you take in. Obviously, your body burns a specific number of calories just maintaining your systems, you know, regulating body temperature, breathing, all that kind of stuff. But yeah. I do like pesto with a lot of Parmesan. However, pasta is a no-no for your gyro, as it has carbs in it. And I have done no physical activity today other than running my mouth and being irritated with Amber. If only humor burned calories, I would be the fittest chick alive. Just kidding. But yeah, I can't have. Oh, good, Amelia. Eat mine too. Let me live vicariously through you. No carbs for you, girl. Because, you know, it's high pressure living in the Floridas, y'all. It's almost all the time shorts weather, you know? You can't like hide the weight like under a good chunky sweater. You know, I love a chunky sweater. I have a ton of chunky sweaters, but the chunky sweaters live in my trunk. It's really my mom's trunk. I love that trunk. I always loved that trunk as a kid because that's where my mom would, like, the change of the seasons. This has nothing to do with anything. I'm just killing time before I end the live. But when I was growing up, my mom would only let us have the appropriate seasoned clothing in our drawers because we didn't have, like, I can't, I feel like we didn't have a lot of drawers when we were young. As we got like 10, 11, when we moved to Texas, things changed. So anyway, you know, we would have summer in the summer, obviously. So the off season clothes went in the trunk. And it was always fun to, when the change of seasons came, go through the trunk and get your clothes out that you hadn't seen in a while. You know what I mean? And now that trunk is sitting in my bedroom, and it's just like, and I don't do that to my kids because I need the trunk. I refuse to let go of my sweaters. I have actually a really adorable winter wardrobe. I've got cute toboggans, I've got cute sweaters, I've got cute scarves. I have the whole toboggan scarf mitten coordinated. Ugh, I have such cute stuff. Yeah, cement shoes. The clothing arguments are the only thing that's left, and that's 2 hours each. So this is what'll happen. Tomorrow they're going to resume court. She's going to read the jury instructions. And then there will be closing arguments. And they each get 2 hours. So that should be a full day of court. So I think I'll stay with you guys through the full day tomorrow, as it is our last day. I feel like we should do that together. But for now, I'm going to sign off, and thank you all for being here. Thank you for the great chat. Thank you to the mods. Thank you all for supporting me. Thank you for the super chat, mi amor, Michelle. I appreciate it. Give your girl a thumbs up or a thumbs down. I don't want to control anybody's emotions. I'm not going to tell y'all how to feel. I'm not that kind of gal. All right. But I will be back live tonight, and we're going to go through all of this. We're going to unpack today, even more than we unpacked it. And then some more stuff too, because there's some other rebuttal witnesses that I talked about last night that I want to talk about tonight, because we haven't heard from them yet. And now I know we got time. All right. So I'll see you guys tonight at 9 Eastern. Y'all have a great rest of your day and be safe out here on these YouTube streets. Thank you, Tony. Love you more than my luggage. All right. Bye, y'all.